We're going to start on time because all of you are here on time, so thank you so much. So my name is Rachel Bronstein, and I am the Managing Policy Attorney at Her Justice, and this is...
Hi, I'm Denise Cronstedt. I'm the Director of Advocacy and Policy and the Deputy Executive Director of the Fund for Modern Courts.
And we'll tell you a bit about our organizations shortly. I think to start things off, you can see a little bit about Her Justice if we watch a video that we are proud of. So here we're going to do this. And if folks are ready, we'll start.
As a lawyer and a New Yorker, I am proud to live in a city that takes care of its own. At Her Justice, we provide legal services to low-income women in crisis in the areas of family, matrimonial, and immigration law. Last year, Her Justice provided legal services to over 3,000 women, and there are over 4,000 children. Our clients are incredibly strong, and many of them have survived great hardship. What they don't have is access. Her Justice makes sure that our clients receive that access by connecting them with private attorneys from around the city so that our clients have access to the legal tools that give them safety, security, and self-sufficiency.
We used to fight a lot, and he used to abuse me physically to a point that in more than one occasion I thought to end my life because there was no other way out.
He wanted my pension, 401k, medical benefits. He wanted my furniture at one time. It seemed like he was winning all along, you know?
My client was arrested because her abuser had actually called the New York Police Department and alleged that our client was harassing him.
My marriage was built on deceit, and it escalated from verbal abuse to physical.
Quería romper un ciclo que no era beneficioso para mí ni para mis hijos. Tú vas a salir de casa y mi hijo se va a quedar en casa.
Court itself, it is not being operated in a way that is helpful to the very people that it was set up to serve.
While our clients may have compelling stories, it doesn't necessarily mean that their entire stories can be heard without lawyers stepping in.
When people go to courts and they don't have a lawyer, they come up short, even when the law's been designed to protect them.
When we have 12 attorneys on staff who can then leverage the legal support from the private bar, we are able to represent and help over 7,000 people every year.
Because of the law firms that donate their services to us, and because of our people that within our walls are able to train them, help and represent our clients, that is how we are able to best serve the community.
The work of Her Justice is vital to women who are not in a very empowered status. It can be very difficult for them to assert the rights that they do have. Her Justice empowers these women to understand that they do have rights.
Many of our clients are completely in the dark about the financial circumstances of their marriage. We know that our pro bono attorneys can make the biggest difference in the lives of those clients by partnering often with financial accounting firms to investigate the income of the spouse and get the client a fair financial award.
We'll look for hidden facts such as if a defendant's hiding income, hiding employment, hiding assets, and we use our investigative experience to get the information that's most helpful to Her Justice and the pro bono attorneys.
Providing pro bono services means that I get to see those results on someone's face when they get an order of support or an order of protection to get them the financial means that they need to help raise their child or to get them safety away from someone who's putting them in danger.
We know we have these incredible mentors, brilliant, talented, resourceful, responsive attorneys who sort of have our back on every matter.
In my experience working with the attorneys at Her Justice, I have been so impressed by their dedication and commitment and the quality of service that they've provided to their clients. I actually grew up in foster care in New York, and as a child, I never had access to the quality of professional and legal services that Her Justice provides.
I think her life is unimaginably different because she came in contact with Her Justice. She might have been deported by now. Instead, she has status and she's living with her daughter here.
If I didn't have Her Justice there to help me with the case, I would still be married to the man who raped me and tortured me.
The fact that Alice's husband was sentenced to 40 years in prison really speaks speaks to the brutality of what Alice endured. Without her justice, Alice would have had to face her abuser in trial alone.
Judge ordered that he does not get any part of my retirement or 401k or any medical or furniture or whatever he wanted. He's getting nothing.
I was an illegal immigrant. I have a work permit now. The fact that I had a social security number and I was able to have a bank account to deposit my check, it was like I'm normal.
I don't think I'll be who I am today. Confident, relaxed, secure, happy. Without her justice, my life would be totally different.
As a lifelong New Yorker, I'm proud to be part of the Her Justice community, where we shift the power to the low-income women who call us every day, who are seeking to build safer and more secure lives for themselves and their children.
Ha sido difícil los cambios, pero lo importante que tenemos es la tranquilidad y estamos saliendo adelante gracias a esta agencia, Her Justice.
I want to thank Her Justice for the amazing team that inspires you to put your best foot forward.
I want to thank Her Justice for giving me my life back.
Give her opportunity.
Horia. Dignity.
Shivang.
Give her courage.
For security.
Access.
Compassion.
Un mejor futuro.
A new beginning.
Give her justice.
Hi, everyone. So my name is Denise Kronstadt, and I'm the, as I said before, I'll say it again, I'm the Deputy Director and Director of Advocacy for an organization called the Fund for Modern Courts. The fund has been around about, I think, 60 years, as have I. And the fund basically is a good government group dealing exclusively with reform in the New York State court system. We've done work outside of New York State also, but our focus is in New York State. So one of the projects that the fund has always done is court observation, court monitoring, court watch. These are all the different words that we use to describe it. So I always like to use this quote because especially when we have the public come in, and many of you are paralegals or attorneys or students that come to see proceedings, but basically we're all part of the public. You just may have special skills. So it is desirable that the trial of causes of action should take place under the public eye, not because of the controversies of one citizen with another are of public concern, but because it is of the highest moment that those who administer justice should always act under the sense of public responsibility, and that every citizen should be able to satisfy himself, herself, themselves with their own eyes as to the mode in which a public duty is performed. So, court monitoring, as I said, is also known as court watch or court observation. And I'll tell you why we have these different names. So I tend to call it court monitoring. But judges don't really like for you to call it court monitoring, so sometimes we just call it court watch or court observation. But ultimately, what you are doing is a process of observing and gathering information on court practices and procedures as a vehicle for promoting improvement in the justice system. It's basically what it is. So I always like, sometimes in different projects, because there are many different court watch projects across the country. So I often like to give everybody a little sense of what it takes to do a court watch project, because it's not like you're just going in there without all this groundwork that comes before, right? I mean, people that do this really have to develop it. So you always want to choose locations that make sense. There are issues, experts, advocates, a volunteer base. And that means that are there issues in that court? Are there people that could watch that court? Are there experts that know about that court? You can't just go in anywhere. You have to have a combination of those things. And you always want to engage with the stakeholders on the ground who understand the issues impacting the communities they serve. So Her Justice, as you just saw in the video, works with women, works with victims of domestic violence, and they work to improve the system. And one of the things to focus on here is child support. So those are the stakeholders, right? And there have to be these relationships with the court system itself in order to have a functioning court watch program. And that's because on the other side of it, you want to be able to communicate and make improvements. Okay, so you can, people sometimes, you can go in there and just watch, but if you have relationships with the court and they are familiar with the fact that you're coming in, they're not thrilled and delighted, but at least you're opening the doors a bit to have an opportunity on the other side to continue with the conversations. Were they thrilled and delighted that we were coming into this? You know, but now that the process is happening, it's okay. And then in order to, you have to know the law, which Rachel will offer you. You all don't have to know the law like you know what you're practicing on now, but you have to have a familiarity with it in order to go in there and know what you're seeing, but you don't have to know everything. You're not representing the people. And then there's this questionnaire that's been created here and that has been tested. I mean, I think you have over 700 observations so far, but prior to that, we tested it, went into the court, saw how it worked, improved it. Because you can't always see what's happening just because you're sitting there, just because you're a lawyer, okay? And then there's always the finding the volunteers, training, and then staying connected throughout the project. So the challenges are twofold in terms of the actual process. One is that court personnel may be resistant to change and may view the monitoring program with hostility, and nobody wants to be watched. Bottom line, teachers don't want to be watched. Nobody wants to be watched, really. And then sometimes it's difficult on the other side of a court monitoring project to measure what kind of success you've had. But, you know, it's one tool in the toolbox of making changes in the system. I will say that I don't think there's hostility now to you coming because people have gone before you, maybe, and they know that you're coming. So why do we do observations? So we want to engage the public to improve the justice system, educate the public about the processes of courts, build relationships between the public stakeholders in the court system. And you know, it really is true, the very act of being present there matters. It promotes this open and transparent court process and strengthens our democracy. I just worked on a project with Everytown for Gun Safety to develop a court monitoring program in Rhode Island on domestic violence and gun relinquishment because they're advocating for changes in those laws. And there was so much resistance by the court system to bringing in lay volunteers. But the reality is they will make a change just by sitting there, let alone gathering all the data. So it's really critical. I often say that the court system is the least watched branch of government. So whenever we, especially if you're not an attorney going in or not a litigant, so we need to watch the court system. We do, especially now. And then what you're doing will provide information for and advocate for reform with partners. So it's this beautiful system that really works. So the benefits is, I'm repetitive, but the benefits is that observing the courts on a regular basis, which is what Her Justice is doing, not just once or twice, but over more than a year now, I would say, you get this ongoing public presence with an independent viewpoint. And then through those observations, individuals and organizations can provide feedback, and that is what's going to happen at the end of this project. There'll be feedback, there'll be reporting, there'll be data, there'll be anecdotes, there'll be stories, there'll be negotiations, there'll be suggestions, there'll be recommendations as to how to improve these child support proceedings, which need improvement. And then challenges for you all. I don't know, some of these may not be true in this case, but it takes time to understand the court processes. You know, if you're involved in the law, you're an associate, you're whatever your position will be, don't presume you're going to know what the processes are in these proceedings right away. You know, they're different, right? So it takes a little time to get in the rhythm of it. And just lower your expectations as to your own knowledge base when you're sitting there. Just follow along. You'll be able to answer the questionnaire. You'll be trained on it. But don't think you have to know everything, which I bet this crowd is guilty of thinking they have to know everything, okay? Having been a person who thinks I have to know everything, that's how we are. Sometimes it's hard to hear. It won't be hard to hear in these cases because it's like you're this close. So sometimes that's a big issue. It's hard to hear. And then the facts of the cases can be kind of disturbing, not kind of, but actually disturbing, very disturbing. But that's the reality of the cases. And there's multiple levels of things that are disturbing, just people's not knowing things. You know, I watched in Staten Island. I wanted to jump in, and I also wanted to jump out, right? It was both things. I wanted to get involved in the case and say, you know, I think I can resolve this in like 5 minutes. And then the other thing was I need to get out of here because it was just so intense. How problems become so much greater than those of us on the outside think they need to be. And then there is domestic violence, and yet people are sitting right like this, which really is wrong in those proceedings. So basic guidelines to follow. Be neutral in your mind. Just be neutral as you watch. You're not going to be neutral, but you know, just be mindful of that as you're watching. And remain quiet and somewhat invisible. And I always like to say to stand in the shoes of the litigants, and here I just have litigant, but because if you don't understand what's happening, I promise they don't understand what's happening. Don't think, oh, they've been here 5, 20, 30 times and they know exactly what's going down and I'm just missing something. I don't think so. So just remember that. And no, you can't understand everything. I always emphasize that, particularly with the public. And then this is something so you want to balance a sense of respect of the court system with a discerning eye. You know, there is that element of respecting judges, what their job is and what they do, which is critically important, and also that you'll see they're under unbelievable pressure in these cases. They turn over quickly, they got a clock, it has a number on it, and it just, but that deference can also be tempered by your discerning eye as to, I'm not quite sure about this. So you have to balance that, okay? And then just practical considerations. I think this is different maybe than this project, but I often tell people just to know that go and sit there before you fill out the form, but I think you all probably can fill out the form right away. And then consider the questions on the questionnaire as a learning process for you also. Like, why are these questions being asked? That could help teach you what's happening. And this is not necessarily for you either, but with lay volunteers, I often say, just wait to offer comments, because I know I would impulsively say, you know, what the hell is going on here? The judge seems blah, 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 blah. You know, give it a little time to really judge the judges. So that's, I think, different for maybe you all. And that's my presentation. This is who we are. And I believe that court monitoring, there are court monitoring projects going on now for bail reform. There's court monitoring going on for domestic violence in various places across the country. There's court monitoring going on for different criminal justice reforms. There's one, people are talking about the new Raise the Age law, which changed the age of criminal responsibility in New York, so that 16 and 17-year-olds are treated in the juvenile justice system instead of the criminal justice system. There's conversations about checking in to see how that's going. There's a project out in Seattle where they look at sexual assault cases. It's huge now, and it's really important. So I, for one, am appreciative of everybody volunteering to do this, and I will now hand it over to you.
Thank you. So a couple of quick housekeeping things. In front of you, you should have PowerPoints. I don't know if you have this tool. I cannot remember if we asked for this to be printed. A 2-pager. Is this in front of everybody? I don't think it is. Is it? Oh, it is at the back. Beautiful. If everybody could just take that out. So, as Denise mentioned, we've been doing this project just about a year now. And I think this is our 5th or 6th training. We've got over 600 cases observed. And so we've learned a lot from the process. And so I want to teach this in a slightly different way than I have before, having also recently reviewed most of those 600 plus observations. And I think it's important for you to be looking at, does everybody have this? Yeah. I think it's important for you to be looking at this. It might be on 2 pages for you, but mine's back in front. And so I want to teach it to that because I think it'll make your experience even more meaningful, and also the data that you're collecting more meaningful to us. So again, my name is Rachel Bronstein. I am the managing policy attorney at Her Justice. As you saw from our video, we are primarily a direct services organization. We, with our 12 lawyers on staff, leverage the talent, resources, support of lawyers at law firms around the city to provide pro bono or free of charge representation to women living in poverty in divorce cases, family court cases, and in immigration matters. Over the 25 years of our organization's history, we've learned a lot because of our huge reach through that leverage model, our pro bono first model that we as we call it. And a couple of years ago, I came into this position as managing policy attorney to really look at the systemic issues that our clients are facing in their cases and opportunities for reform. And one of the areas where we see a lot of opportunity for reform is in the family court. There are a lot of challenges to access to justice in the family court. We're going to talk about those through the lens of child support. One of the reasons why child support is because, let's see, I got through this. Okay, why child support? The reason for this project to focus on child support, there are a few reasons. One is that over 90% of litigants in the New York City family courts in child support cases have no lawyer. You will see how complicated that is. I think that I had been a law firm lawyer myself, and I think I wouldn't have understood the system either, even with a law degree and even with an education that I'm proud of. But for many people who are unskilled, uneducated, for whom English may not be their first language, I would say it's nearly impossible to fully understand what is happening in child support courts without an advocate, a lawyer, to guide you through the process, and you will see that. So again, over 90% of people have no lawyer. There are about 100,000 filings for child support per year in the New York City family courts, so there are a lot of people going through the family courts. And yet, the family courts are invisible to most of us. Most of us who haven't represented a client in family court or participated in a project like this will never or have never seen the inside of a family court. And as Denise mentioned, the courts are tiny. They're little rooms, maybe like the size of a bedroom, kind of. The setting is at the same time familiar and yet completely foreign and alienating. You're sitting right next to the person who you've sued or who has sued you for child support. There could be issues of domestic violence. The courts actually are working on the way that that issue gets recognized in a family seeking child support, since legally domestic violence is not a consideration for child support, as we'll discuss. So you've got this really interesting setting that this project gives you an opportunity to be part of, and with all the benefits that Denise mentioned to the system. And so that you know, our plan with the hundreds and hundreds of cases that we are proud to have had volunteers report on to us to date. We are in the process, I don't know if some folks from Ancora are here, but Ancora has offered to do pro bono, which is amazing, analysis of the data collected so far. And we're going to see the themes that are emerging from that data. Ultimately, we're going to have some experts in the field sort of review that data. And ultimately, we're going to publish a report on the findings from this project, the observations that you and your colleagues have made for us, and recommendations for change. And for, just to say, I've been involved now for a few years in a lot of policy conversations around child support. We represent women living in poverty. most of our clients are custodial parents, the parents who have the children living with them. This project is looking at the experience of both litigants, both parents in the child support system, and looking at the access to justice issues, which we'll discuss for those parents. But I will say from a policy perspective, the contribution of this report in the context of the work that Her Justice does serving primarily custodial parents, moms, in child support cases and family court cases in general is incredibly valuable. There's a lot of interesting policy conversation going on in New York State, nationally around child support, but my perspective is that there is a major omission of the perspective of a custodial parent struggling to support children without adequate child support. So this is going to be an enormous contribution to the policy conversation. So I am also very grateful for your involvement. So I'm going to take you through very basics of child support. Again, keeping in mind what Denise said, not so that you are going to determine for us whether the court did it right or not. You're not going to know in 9 out of the 10 cases that you see what the result was in terms of, is mom getting $50 a week or $75 or $0 or what? You here and there you may see a case where there's a final order being issued by the judge, and we'll discuss that. But largely you're seeing a mini snapshot of what is happening in this case. So I'm telling you the basis of child support for context. Also, for those of you who are lawyers and may want to represent someone through Her Justice in child support, this is the very beginning of that, that knowledge for you. But I'm not telling you this so that you can tell whether the judge made the right order. So with that in mind, the initial child support order. Child support is based on income. A lot of what you're going to hear is about money. Who's working? What kind of work are they doing? How much money are they earning? Do they get paid on the books? Do they get paid off the books? Is it a cash business? Do they get a W-2? So it is based on income, and in New York State, since state law is what governs child support law, although there are federal policy guidelines on child support, in New York State, children are entitled to child support until the age of 21. That is different in some states, like I think North Carolina, it's till 18, but in New York State, it's to the age of 21. And the premise behind child support is that both parents have an obligation to support their children. Even if the child is living with one parent, that parent is presumably paying the rent that covers that child, the food that covers that child, the clothing necessities, but the other parent has an obligation to contribute. So there is a public policy interest in child support, which is why we have so much law and so much litigation around it. One thing I will say right now to set the stage for how child support is done in New York, and I don't want to get into the weeds on this, but it is important for your observations in court. Some child support litigation in New York, and in all states, is done by public assistance or welfare. In New York, we call it the HRA, the Human Resources Administration. I say that because for a family that is receiving cash welfare, cash payments from the government because they're impoverished, that family has assigned the right to the state to go after, let's say, the father, although of course the law is gender neutral, so it could be that the non-custodial parent is the mother, but let's say the father, since that's the majority of cases. So the family's getting cash payments from the government for welfare. That means the state can go after dad for the child support that should be going to that family instead of the cash welfare. So there's this assignment scheme. I say that because in your cases that you observe, you may see that on the other side, and we're going to look at a court calendar so that you understand in concrete detail what I'm talking about later, you may see that the state is going after the non-custodial parent, let's say dad, for child support. We're not going to record observations about those cases. The dynamic is different. The government is on one side. What we're interested in are the cases where there are two private parent, regular parents, mom, dad, mom, whatever the configuration is, and one of those parents is asking the court to apply child support from the other parent. So I just say that because New York has a complicated scheme. New York does everything in a complicated way. And in New York, there's a lot of child support done where mom petitions the court, give me child support from dad. But there is also this public assistance welfare scheme that happens in court. And for better or worse, at the exact time that we initiated this project, the New York court system changed so that now those public assistance cases are mixed with the private litigant parent cases. It used to be that those cases were only done in a certain courtroom. Unfortunately, for our teaching purposes, those cases are mixed. So I have to tell you what to avoid, and I will show you on a calendar later what exactly I mean. Okay, so also what we're not observing, one more thing, spousal support cases. Like child support, there is a law for spousal support between married people. So people in family court can be married with a child in common or unmarried with a child in common. When people are married with a child in common, you may see that mom, let's say, has petitioned both for child support and spousal support, or alimony, sometimes we hear it called, from the other spouse in this case. We are not observing those cases. I will also show you how to understand that you're seeing one of those. Again, if you write down observations about one of those cases, it's okay, but I'm teaching you this for the best clarity of our data. But it's okay if you write down observations and submit them for a spousal support case. But if you see a case where someone says, we've been married for 10 years, he makes $50,000, I make $20,000, judge, I'm asking you to give me spousal support, and there's no discussion of children, just take a break. Sit back, take a break. Okay. Paternity. And this is one of the things I'm going to show you now. I want to teach to this form that you have. Again, look at the court monitoring, child support court monitoring project with the boxes on it. You're going to see that we're talking in box 2 about case type. So I'm going to try to tie what I'm talking about to that. An initial issue in child support can be paternity. This is a very traditional and in some ways outmoded concept because our families have been looking different than our laws have, and finally our laws are catching up to looking at the full breadth of parentage, that it's not just a man and a woman who are parents or a biological parent. There are adoptive parents and same-sex parents, but paternity is stuck in the time where you have a mother giving birth and a father who's the father of that child. The court is looking at, right, because parents have an obligation to support, is paternity established? So you might hear discussions about, I'm not the father, or he is the father, or DNA tests, or these kinds of words around a paternity issue. The law presumes, again, outmoded, but the law presumes that parents who are married at the time of a birth are the parents of a child. We know from our clients and our lives in general that's often not the case. I have many clients who she was married to someone at the time that her child was born of a different relationship. In that instance, you have to prove paternity of the other parent. And the reason to prove paternity might be several different things. 1, to get child support. 2, you won't see this in your cases, but sometimes people are discussing paternity in court because dad's saying, I am the father of this child. I want to seek custody of this child. I want to seek visitation with this child. So paternity comes up in family court a lot. There's something called an acknowledgement of paternity. You might hear that. For people who are not married at the time of a birth, the father in the hospital when the child is born signs a form that is called an acknowledgement of paternity, saying, I am the father of this child. So you might hear, was an acknowledgement of paternity signed? These are buzzwords. You might hear, but it's really legal, that the father is called a putative father, like a would-be father, before the court establishes paternity. And importantly, you might hear that the court says, okay, paternity established. I'm going to issue an order of filiation. Talk about another gendered word. But filiation is parentage, right? That you are the parent, you are the child of a particular man. Many of our clients seek this first. And so you will see on the court calendar when we turn to that, there is a P docket number, P paternity. And I'll show you what that looks like on the court calendar. And again, in New York State, our law is finally catching up to our reality, and more parentage is being discussed. But the courts are behind, and so you'll hear more conversation about paternity, okay? So if that is an issue that you hear, chances are that in your case type is an initial child support determination. In a family's life, here's what might happen. Two people have a child together, they split up. The person with the child, let's say mom, that the person is living with the child primarily, needs support, goes to petition in family court. If they were never married, paternity might be an issue. But what she's doing in that initial petition there is asking the court to order child support for the first time because it hasn't been ordered before. Let's say she gets an order of child support. It's paid by dad for a couple of years and suddenly his job changes and he stops paying. Now that family might be back in court years later because she's seeking to enforce, and we're going to talk about this, enforce the order of child support, or he's seeking to modify it. We're going to talk about that. I lost my job. I can't pay $100 a week anymore. I don't have an income. So these are different circumstances in life that might bring a family back to family court. But at the paternity initial child support determination, case type number 2 here, you might check off initial child support. These people have never gotten an order of child support before, and paternity is being discussed, okay? And again, if you have questions while I'm talking, please ask me. Okay, very basic here. Child support is a few different components. It is a basic obligation, which is $50 a week, $100 a week, based on income. It is mandatory add-ons, what healthcare out-of-pocket costs need to be paid. You might hear discussions of health insurance, who's covering the child, are there co-pays, and then some discretionary add-ons. So let's just briefly look at this. I don't want to take a long time to look at this, the formula for child support, because you probably won't hear the court doing this, and the reason you won't hear it is because the court does this by a calculator, like an actual calculator. There are easy cases in child support. The cases that are easy are where parents are earning on the books W-2 income. If I show up in family court and I'm earning $50,000 and the other parent's earning $70,000 and we have our W-2s, the court takes out a calculator and says, okay, 2 children, 25% of those combined amounts is this annual obligation. Since I earn half of the combined parental income, I pay half, and he earns another half, he pays half. Since the child lives with me, I'm not going to actually pay child support, but the child doesn't live with him, and he'll pay that amount. So there is an actual calculation that the court does with these percentages in mind. Imagine if you have 6 children, you will not be getting a lot of child support. And those are the easy cases. Let me tell you, there are many, many, many cases that are not so easy. They're cash income on the other side. There are people who are undocumented and don't have legal work authorization, and so they're not earning on the books. There are people who have a family business, and the accounting is not as straightforward as one might hope. So there are lots and lots of cases that are not so easy. There are also, this has become a sort of pet project out of all of this policy work on child support, there's a huge problem with public education. That scenario I just described where everyone shows up with their W-2s does not happen. Maybe it happens on the second appearance or the third appearance in a case. But off the bat, it is, in my view, rare to see people show up, even when income is easy because it's on a W-2 or a pay stub. It is rare to show up in court on the first appearance with everyone with their information. We have a major problem in this system, which is that in some ways we think it's more complicated than it is, and it's been a barrier, I think, from a systemic institutional standpoint to us adequately educating people. Here's what you need to do when you show up in court for child support. You need to bring your W-2. You need to bring proof of your income, whatever that looks like. If we did that, we wouldn't have so many adjournments, which is something we're going to talk about in a moment. So it's rare that you're going to see such clear presentation of information to the court, but in theory, that's what's supposed to be happening. And the idea with this part of the calculation, which I really breeze through, is that you're looking at each person's income minus some deductions for taxes. Income is very broadly defined. So even our own clients who are undocumented, cleaning houses without proof of income, if they're earning $400 a week in cash, that's their income for purposes of child support. Proving that has become challenging, and there are really interesting overlays, since I mentioned immigration, with immigration issues in family court, but income is income. Lottery winnings are income. Illegal drug proceeds are income. So the courts take a broad look at income because of the public policy of getting child support to children. You might hear in the deduction category here, dad say, well, I pay child support for 3 other children. The law says that if you do pay child support for 3 other children, then that should be deducted from your income, but only if it's pursuant to another court order or a legally enforceable written agreement. So if I come in and say, well, I'm paying child support for my 3 children under the age of 5, and I live with them, but I don't have a child support order because I'm living with those children, the court may consider that, which, you can talk about whether that's fair, the may consider that part, but it's not in the statute that the court must consider that. So you may hear a lot about that. You might hear dad coming in and saying, well, she's got a child support order from me for $100 a week, but I just have a new baby. I can't pay $100 a week because I have a new baby. And in some ways, again, fair or not, the system is first to file. If mom filed of the 5-year-old before mom of the new baby, mom of the 5-year-old gets the full amount of dad's income for consideration for child support. So you may hear that, and I wish I could give you the magic answer to whether you'll hear dad saying, I have another child, I should pay less in the initial child support determination, or, again, case type, in a modification. You might hear dad saying, I can't pay $100 a week anymore. I need that to be lower because I have a new baby. That's probably a modification, right? Dad's coming back into court and saying, I need that old order to change. But if dad just comes for the first time and mom says, I want child support from him, and he says, well, I may make $40,000 a year, but I have 3 other children, that might be the first time that these 2 people are trying to get child support. Again, you're going to do the best you can with this. If you're confused, the litigants are confused also, but I'm teaching you so that maybe you can get some of this. And why it's important to us, by the way, why we even are asking you these substantive questions, is because our hope is to be able to report at the initial child support stage, when people are first in court as a family looking for child support, before the judge has ordered a child support amount. These are the kinds of adjournments or postponements we're seeing. At the modification stage, this family already has an order of child support and is coming back. These are the kinds of postponements or adjournments or problem we're seeing. So our hope is to be able to tie it to a case type, but again, don't worry yourselves about getting it wrong. Just don't worry yourselves. I'm teaching you for the best case scenario, but don't worry. And again, the courts are looking at everyone's income. I want to say here that you might hear in the imputing income, which is an important policy issue, which is where someone, the non-custodial parent's not working, or lost a job, or sometimes in our cases, suspiciously lost a job right after the child support petition was filed by mom. There is a function of the law that allows the support magistrate, the judge presiding over the case, to impute income, to say, well, sir, last week or last month or last year you were earning $50,000 as a maintenance worker and you're not working now. So your former income is what I'm going to use to calculate child support. The idea is that the court, again, is looking for child support for this child and can do this. Does it sound punitive? In some ways it can sound punitive, yes. You may also hear in this discussion, Dad, I don't have a job. I can't pay child support. Go out and show me proof of your efforts to find a job. come back in a month. I'm going to adjourn this case. Come back in a month and show me that you went to this business, went on this website, tried to get this job. So show me that you're trying to work. And then we'll talk about whether imputing income at a former income that you had is fair. We have a lot of cases, and we really take the hard cases at Her Justice, cases where we really think they would be very difficult for one of our clients or would-be clients to do on her own. We have cases where we go to trial. Labor statistics, the average income of a plumber is $60,000 a year in New York City. And dad hasn't shown ability to get a different job through multiple court appearances in the case. We put on evidence. We put a vocational expert on the stand and say, this is what dad could be earning. This child, he should be earning. There's no barrier to his working. He's able-bodied. Court, impute that income to him. And sometimes we say, well, isn't that funny? Dad's on Facebook showing that he just bought a new Mercedes, or he's working, 3 jobs at a nightclub and showing dollar bills or whatever it is. Let's look at his lifestyle. Let's look at his spending. He clearly is able to pay more than 0 for this child. So these are things that you will probably see if you're looking at a case where there is a trial or fact-finding hearing. And we'll get to that stage shortly. And then sometimes you might see a case, and in terms of appearance type, there's an initial time that the case is on in front of a support magistrate. This is the first time that people are showing up. But then there will likely be multiple other times that the people are appearing in front of the judge before ultimately you get to trial. For those of you who are litigators, family court is bound by the civil practice laws and rules, by the rules of evidence, so the arc of a litigation looks like any other litigation. You file your pleadings, in this case a petition to start the case. You have your first appearance in front of a judge. You have multiple other conferences where you're exchanging information and evidence, and then ultimately you go to a hearing or you settle. So it does look like any other litigation for those of you who are litigators. Ultimately, if through the process of discovery, the lawyer hopefully there is a lawyer for the petitioner, the person asking for child support, cannot prove what the non-custodial parent's income is. Just cannot be proven. That person the litigant or the lawyer can put on evidence. What are the needs of this child? The document that is key, which you may hear discussed, financial disclosure affidavit. If you're curious what that thing looks like and to understand what the litigants in these cases are going through, you can Google New York financial disclosure affidavit. The long form of that document is 8 or 10 pages. It is basically an assets liability statement. What kinds of income do you have? What kinds of expenses do you have? What are your assets? What are your liabilities? Ask yourself, if you were an unskilled, uneducated person, perhaps English is not your first language, if you would be able to adequately fill that thing out. I don't think I would be able to, and I have a lot of those privileges. Those are supposed to be exchanged in the beginning of a case. So you will hear the support magistrate say, did you bring in your financial disclosure affidavit? You're supposed to have it. Come back next time with it. Again, to the public education point, do people know what they're supposed to do? Is there anyone to help people fill these things out? Where those have been exchanged or provided to the court, the petitioner, the custodial parent, or the lawyer may say, as I put on my financial disclosure affidavit, the household food expenses are $600 a month. The household rent is $1,200 a month. The child's portion of that is 1/3, let's say. And those are the needs of the child. Support magistrate, order child support on that basis. Is this perfect? No, because it's not tied to income. It's not tied to the father's, let's say, ability to pay. But as a last resort, the Family Court Act empowers the support magistrate to do it this way. And then I just quickly, you may hear these discussions. Childcare. I have to pay, when I'm at work, I pay a babysitter $150 a week. Do you have proof of that, says the support magistrate. Here's a receipt for the cash I pay my babysitter. This is a discussion about the initial components of child support. And so, again, case type, initial child support determination. Or you might hear in the modification context, Mom, I'm back to court. I'm back to court because When I was last in court, Judge, and you gave me a $100 a week child support order, now I'm working. And now I have child care. My child care expenses are X amount of dollars. Or something changed with health insurance. Co-pays went up. Or my child had surgery and there are medical bills. I want you to ask that dad pay his pro rata share. You may hear this. It's the relative portion of the family's income. If I earn half the income of the two of us, he earns the other half, we split these expenses half and half. If I earn 20% of that family income and he earns 80%, he pays 80%. So you might hear pro rata income. These are components of a basic child support order that you might hear the court talking about. And then there are discretionary add-ons. You might hear people talking, litigants talking about college tuition expenses. You know, Judge, when we got divorced 5 years ago, or 10 years ago, we didn't have as part of our divorce judgment who was going to pay the college costs. And now, Junior is 17 and we're facing college costs. I want dad to pay his portion of those. So you might see people coming back to court for that. These are discretionary. These are, the court may order these as part of child support, but need not as a matter of law. So you might hear that. Just so you're not going to see this in court, but just for your edification, this is what an order looks like. You see that there's a support magistrate listed at the top. There's a file number and a docket number to the right, which we're going to look at on the court calendar in a moment. And you see the parties' names. In this case, mom's a petitioner, dad's a respondent. And there's an obligation summary there. So this is what comes at the end of a case. There's a basic payment here. There's a child care payment. You see that there's SCU mentioned. You may hear that, Support Collection Unit. In child support cases, the custodial parent, the person who's going to receive child care, has the option. Do I want those payments to come to dad directly, from dad directly? Do I want him to send me a check every month or a check every week? Or do I want this agency of the state, the Support Collection Unit, to act as a middle agency between me and dad? We just, so you know, especially in cases with domestic violence in the past for the family, we always recommend that SCU collect the money. So what that looks like is dad submits a check to an address in Albany. That agency then remits it to mom in an electronic account. SCU also has certain enforcement powers. They can garnish wages if dad works on the books. They can, where dad's not paying, they can suspend driver's licenses, withhold a passport, and other enforcement mechanisms. So that's what SCU there is. Okay, real quick, you might hear arguments about deviations. Judge, I know you set a temporary order, and again, let's look at our, on the final page, outcome, box 15, there is a box for temporary order entered. The court must, does this always happen? No. But the court must, by statute, at the first appearance that these people are before the court, where there's been no child support ever ordered between these two people, the court must enter a temporary order. Does this always happen? No. Especially, again, coming back to this problem of lack of public education, no one shows up with documents that first appearance. How is the court supposed to enter a temporary order? The court can do it on mom's word or dad's word. Dad says, yeah, I'm working as a plumber, I earn $60,000. And mom says, you know, I'm barely scraping by here. And the court will say, okay, $50 a week, we're adjourning this for 6 weeks. When you come back in 6 weeks, bring that financial disclosure affidavit. Bring proof of your income so I can set the right order. So the temporary order could be issued and should be issued at the first appearance. You see at the appearance type in box 1, return of process, first appearance. It isn't always. But you may hear then in subsequent appearances before the support magistrate that the parties are saying it's too much. You know, Judge, my only income is SSI, supplemental supplemental security income, or SSD, disability income, or, I'm not working right now. So deviate or adjust the child support. So you might hear, again, a lot of arguments about that. I always want to say this because I feel like it's a pretty stunning figure, but again, 90% of people have no lawyers, unbelievably complicated system. Many people end a child support litigation without a lawyer to do discovery of income or assets of the other party, without someone to navigate the process for you, with the legal minimum amount of child support, which is $25 a month, regardless of how many children you have. So think that through. And, I think you'll understand why we do a lot of work in this area, because if you can't advocate for yourself in this complicated system and the court has no information to go on, and even the needs of the child analysis fails for some reason, many people end up with a $25 a month award. And you might have 3 children for which you're supposed to have, who you're supposed to feed on $25 a month. So very, very dire consequences of not having an attorney. Okay, few points here. Let me just check my time. Okay, fine. Any questions so far? I know there's a lot of information. Okay, so again, we talked about the initial order of support. The first time people go to court is called the return date. You want to say? Yeah.
I just want to point something out to everybody that's sitting here, that there's this beautiful booklet in your package. So there's a lot of information being offered to you. Everything is in here.
Yeah.
So just so you're not like, oh my God,
right.
Whoa.
Right.
It's all here. The process for the project, the chronology of what goes on in court, the definitions of things, as well as the questions that are asked, what those questions are seeking. So it's all in here.
Yeah.
Okay.
And you should read that before you go.
Yeah, you should read it.
Yes. As a recap.
And bring it with you.
And bring it with you.
You can cheat in there. You don't have to go there like you're taking a test. You can actually have papers and a clipboard and all those things.
Yeah, and we'll talk about the logistics of that, but Denise is right. This is all in there. So the first time people appear in court, a big issue, and again, I just recently analyzed or reviewed really the 600 plus observations we have. A big issue is service. You will hear this. So as in any kind of civil case or criminal case, litigants have a due process right. The respondent, the person being sued for child support, has a due process right to have adequate notice of the case against him or her. So again, like if you get in a car accident and you sue the other person for damages, it's the same thing. If you're in child support and mom sues dad for child support, she must effectuate service. How that gets done needn't really concern you, but know that it has to be done. And in court, they call this the return date, or return of process as in service of process. So you, in the first instance, the petitioner has to prove to the court that the other person was served. Now, if the other person is sitting there in court and not saying, but I wasn't adequately served, service is a non-issue, because clearly the person had notice, they knew to come to court, and they're not making an issue of service. So you may not hear a discussion about this, but I did see a lot of observations, which makes perfect sense to me, because a lot of the cases you will be observing are the first appearance cases, and I'll show you that on the calendar. A lot of discussion about where's the respondent. So mom is the only one sitting there, and the court says, okay, case number whatever, where's the respondent? And she says, well, I couldn't get him served. My sister was going to do it. He wasn't home. We couldn't get him handed the notice to appear in court. The court will say, all right, adjourned, try again. So now it's postponed for 6 or 8 weeks, depending on the court's calendar, whatever the timing is. So service is an issue. And so you would click off in the outcome box, adjourned to service on the respondent, okay? So service comes up a lot. And people duck service, and, I think people are afraid of child support court or court in general. So you will see that happens a lot. Where both people are sitting there, and service is not being disputed in any way, the court is going to be asking these questions. Where's your financial disclosure affidavit, as I mentioned? Where's your proof of income? Sir, what do you do for a living? Ma'am, what do you do for a living? Where's your W-2? Where's your receipt from your employer? And where those things are provided, as I said, in an ideal world, the court is securing or issuing a temporary order. Just so you know, the court's not going to hand a paper of a temporary order to the litigants. A lot of times the court will say, we'll mail it out, or if you wait around, I'll get that paper for you. Our clients are often very confused about that, what they leave with. And this is kind of one of the things that we're asking. Did the magistrate explain what happens next? So this is one of the things you're going to be looking out for, and we'll go through some of those questions. And sometimes the court will say, do you want a lawyer? Is anyone going to come back with a lawyer? Now, as I think I said in the beginning, there is no right to an attorney in a child support case. If you are poor, the court does not have an obligation under the law to provide an attorney for you. For context, in a custody case, an order of protection case, domestic violence case, and family court, there is a right to an attorney if you're poor. Not in child support cases. There is a view in the law that, and this is a subject of policy discussion these days, but there's a view in the law that on financial matters, like child support, you don't need an attorney. Ask yourselves if that, and that is one of the things actually we ask you to tell us, but ask yourselves if that makes sense. One of the things we ask you to report to us from your subjective opinion is, would these people have been better off with attorneys? Your view. Sometimes it's pretty open and closed. Maybe you don't need an attorney, but your opinion on that is valuable to us. So the court may say, do you want a lawyer? But the court's not saying, because I will give you one. But frequently the court says, if someone says, I've been looking for a lawyer, maybe someone even says, I called her justice, or I called legal aid, and I'm trying to get a lawyer. And the court will say, okay, adjourned, and in your 15-box outcome, adjourned to obtain an attorney. The court, I think, views it as helpful for litigants to have attorneys. And so you will see that it's worth it to the court to delay the case one time to allow people the chance to get an attorney. How likely is it someone comes back with an attorney? Very unlikely. And it's really hard to find pro bono counsel. Our program, it has a wide reach, but even then, we can't meet the demand that's out there. And many other legal services agencies do not do child support cases unless there's also like a custody case or something. With one exception, the right to counsel applies here. And you will see that, perhaps, in the enforcement cases where there is already an order, the custodial parent, frequently mom, is back saying he hasn't paid child support in 2 years. Judge, enforce this against him. In those cases, the respondent, the person who should be paying, frequently dad, has a right to an attorney. And that is because one of the remedies, one of the things the magistrate can do is issue an order of incarceration, up to 6 months in jail. We'll talk about that in a minute. But this is at your first appearance. There are many cases, there are many court appearances in a case. We've been looking at some of our own data from our own represented cases through Her Justice, not through the court watching. How many times do people go to child support court? I don't have a number for you right this minute, but it's at least 6 times. It's not once or twice. It's a rare case where everyone shows up with the documents and an order is issued, or even on the second appearance. Frequently, people are in and out of court 6, 8 times over the course of a year. So many of those check-in appearances are going to be what we're calling compliance conferences. Did you get the documents? Did you bring your financial disclosure affidavit? Did you look for work, sir? These are compliance conferences checking in. So did you bring proof of child care? Did you bring proof of the health care expenses you have, the co-pays? So these are compliance conferences. So don't be afraid on the appearance type, box number 1, to check off compliance conference if it seems like there's a discussion about documents. My take on what I saw in the 600 plus observations I reviewed, a lot of people felt that when there was a discussion about evidence or documents, that it was a hearing or a trial. You won't be seeing many trials. I'm going to show you what that looks like on the calendar, but there are, I don't know what the percentage is, but 90% of the court appearances are something other than a trial. And many of them are these kinds of check-in. What's going on with the case? Where's the information? Did you get a lawyer?
But they're all on the record.
They're all on the record.
So
yeah.
it seems as if.
So it seems as if it's a trial,
Right.
but trials are fairly rare because a lot of the work of any litigation gets done before a trial happens. And just so you, speaking of on the record, you won't see most likely a court reporter or stenographer with the machine. There's an audio recording being done of everything that's being said in court. Okay. Also rare is settlement. I saw a few of these in the 600 plus I reviewed. There is a sort of tale of two cities, or very much a tale of two cities in family court in New York City, which is that, frankly, most people of means do not need to go through family court. I'm not saying that you won't see people of means in family court, but having never done this work for paying clients, my understanding is that a lot of people with means don't want to toil through the family courts, because who would want to? You'll see what I mean by that. So many people reach an out-of-court agreement with their lawyers at a desk in an office, and then file it with the family court and ask for the court's approval of it. We've reached an agreement. This is legally binding. We've got all the recitals, the language we need to have in this written agreement. Court, can you sign off on this? So you will likely see that more so than you will see people hammering out an agreement in court. You might. You know, there are all these complicated things that I list here that need to be in an agreement, but probably you won't see much of this. You might, and if you do, you would check off that the posture of the proceeding in box 3 is settled. By the way, on that box, contested means two people are sitting there. This is a disputed litigation. Default means one person is there, probably the petitioner, since that's the person who started the case, and the respondent didn't show up. So if it's default, that means just one person is there, and that's what you would check off there. Again, this is in the guide. So a note on trial, as I said, rare. If you see a trial, it looks like what you see in your billable cases or on TV. The person who's pursuing the case would testify, would stand up or sit at a desk and say, I've been working at this company for 6 years, my income is this, or I've owned my cash business for this, or my family business, this is how we do our accounting, you know, here's the document for the court. And then the other person would say, here is my hardship, I cannot pay that amount of money, here are all the expenses I have, here's proof of what I'm paying for other children and child support, and there's cross-examination. As I said earlier, because 90+% of these cases are unrepresented, are just two parents sitting there, the court asks a lot of questions. So the court takes over in some ways of the role of an attorney by function of practicality. Let's move this along. Let me elicit the information I need from these people. So you may see that kind of thing happening.
You will see it.
You will. You will, and you will see it even at the non-trial phase. You will see the court directing. I mean, Denise mentioned earlier, you know, there can be 30 cases on in a court's calendar. I'm making up that number. There are many of them. One of the things we ask you to do, which is important, on the top of your monitoring tool here, your protocol, the case schedule time, the case start time, and the case end time. I'll talk in a minute how you're going to know that. The case start time and end time you're going to know because there's a clock on the wall, and when the magistrate calls the next case, you're going to look 10:02. Frequently that case is ending at 10:04, 10:05, 10:10. There are minutes, not 30 minutes long. And this is important for us to be able to see how much time are people getting in front of magistrates. This is not news to the court system. Denise talked about buy-in of the courts. The courts know that we're doing this. You will not be the first people observing the magistrate you observe. And the courts, they know they're overworked. They know they're overburdened. They know they're under-resourced. There aren't enough magistrates to address the need, but it's impactful for us to be able to say the average time that a litigant gets in front of a magistrate is 5 minutes, or whatever it turns out to be. That means a lot for true meaning and procedural fairness of the experience of those litigants.
Rachel, on the form, where if everybody looks at the form, you'll see it says case schedule time. That's on the calendar.
And we're going to look at that in a minute.
Okay.
Yes, because it is important, although in some ways less.
So it's not a mystery to you?
It's not a mystery, although we'll talk about in some ways that it is.
It gets a little confusing sitting there. It took me like 5 cases to know what the hell was happening in front of me. I mean, really, I'm like, well, what number is this? And who are these people? And so there are different things that can help you to figure out which case you're on. You know, it's whether the names of the people jog you, or the time, or, you know, you have to kind of pull it all together and piece it together. But it's pretty wild in there, actually. How, you know, it's like boom.
It's quick. Yeah. It is really quick. And we're going to look at a calendar in a minute, which I think will give you some nice context. I mentioned before the support collection, you might hear that. Again, modification, I mentioned the kind of words you might hear. The standard legally is change in circumstances. You might hear the magistrate say, well, sir, I hear you telling me that you lost your job. You know, how is that, or I hear you telling me that you work fewer hours now. Are you telling me that that's a change, you know, a change in circumstances? Have you proven that that's a change in circumstances? Sir, that's the standard here. Or you were just in court to get a final order a month ago, sir, and now you file for a modification. How could something meaningful have changed in the last month? Well, I just lost my job. Well, isn't that funny? You lost your job a week after, you know, the last court appearance gave you a final order of $100 a week. You know, tell me how that really happened. How is it that there was a change? So you will hear a lot of discussion about that. One thing that came up a lot in the 600 plus I reviewed, termination of orders. When children age out of child support, it is, you know, again, fair or not, it is the obligation of the paying parent to seek a modification, to come back to court and say, my kids are now 21, which is interesting. My kids are now 21, and I shouldn't be paying child support anymore. So if you are hearing words about termination, kids aging out, kids 21, they're adults, that's a modification case. So mark off in case type modification, because someone is asking for a change of a prior order. I'll show you on the calendar, but modification cases at the end of the docket number have a letter. You will see cases that are up to letter K, Z. Those are serial litigation cases. I mean, we could talk, that's a whole other topic of, in my view, abuse of process, but there are a lot of cases or families where there are serial filings for changes. Yeah, go ahead, Matt.
I just want to be clear, because that sounds crazy, that child support doesn't actually stop once you turn the maximum age.
That is right. It is the obligation of the paying parent to seek a termination.
I didn't know that either.
Yeah.
It's wild.
It's wild, and it also goes to the public education point. It also goes to the public education point, which is that people don't know when to come back to court. They don't know the right time to come back to court. A caveat on that is if it's direct payment, dad to mom, and the kid turns 21, which dad will know, he can stop paying. It's the orders that are being garnished or were SCU.
Continue to do that.
Yeah, I mean, you see messy situations all the time in court. The agency communication with the courts is poor. There's a lot of, nobody sort of knows, there's not a streamlined system of, again, when to come back for a change, when to come back for a termination, who is responsible for initiating that.
And can you opt in to CSU anytime, I guess, after, or is that part of, that's another?
That's a good question. The answer is yes. I mean, yes. If we've agreed to the direct payments, dad to mom, and it's not going well, or his job changing now, he's on the books, and I want SU to garnish, yes, you can go back. But you know what happens, again, with a messy system, people go to court for that, and they don't need to go to court. They need to go to the customer service office of the support collection unit. Do they know that they need to go there? No. So you see, I mean, it's another policy point, but you see a lot of people in court for sort of the wrong reasons because they don't know that they don't need to be there. So that 100,000 filings per year, you know, could be a lot fewer if the right people were there for the right reasons.
Right, so those aren't individual, or those aren't unique filings, right? Those are a lot of repeats.
There are a lot of repeats, but they're new petitions every time. So, I mean, we've seen cases that are like letter Z. And because they're tied to, so let's say it's like docket number ending in 2012. So the case started in 2012, but now you're up to 18K. That means that it was a 2012 litigation between these two people. And now in the year 2018, there have been a bunch of filings back and forth. I'm mom seeking to enforce, dad seeking to modify. it fails. Someone doesn't show up, it's dismissed. Again, mom sues to enforce. Dad, I mean, you see it a lot. And especially in cases where there's been a history of domestic violence, there's a major issue which is inadequately addressed by the courts and case law and all that, which is abusive process. And so we see that a lot. So standard for modification. And then sometimes you'll see people come in and say, the child support order is 4 years old. And there's that alone is a statutory basis for a change in, an update in child support. Or there was a change in income. I lost a job, or he sues for modification and says, her job changed. She now has a job. Or I know she got a promotion. Let's adjust. And what's really being adjusted there is not the basic amount of child support, which is primarily based on his income, but the pro rata shares of co-pays, child care. That percentage, since it's a relative percentage of the total income of the parents, that is being adjusted. So those are modification moments, and you'll see those. And you'll see a lot of these, violation enforcements. So another change that happened at the time we launched this project was that some magistrates are specially handling violation enforcement cases. And it was actually a result of some advocacy we've done and a class action lawsuit that's pending in the state courts, which was that the enforcement cases that are, for various statutory reasons, supposed to be handled expeditiously were not being handled expeditiously. I mean, the idea here is a family has been suffering without child support being paid that's due to them. There was already an order of child support, and the payor parent is not paying it. So the idea is the expedient resolution because this family is already suffering. And so you're going to hear in these cases, and I'm going to show you what these look like on the dockets, you're going to hear in these cases a lot of discussion about the ability of the payor parent or the respondent to pay. Why aren't you paying the $100 a week? Well, I lost my job. Come back and show me proof of efforts to get a job. I'm going to refer you to a job placement program, and that's one of the things that is in the outcome box, non-custodial parent ordered to participate in a job training program. The courts actually have resources to train, connect a respondent or payor parent, a non-custodial parent, with job skills. So the courts will sometimes do this. There's a phase of the case that you will see in enforcement cases that is called the post-dispositional review. We can talk offline about the wisdom of that phase, which is an invention of the courts in the last year, but it is a seemingly interminable phase of a case where the court's checking in with dad. Did you get a job? Did you look for a job? How are you going to pay this order that's already been issued, which you are in contempt of court, you failed to pay? And here you're going to hear words like willfulness. The court's looking to see, did dad know about the obligation, or the respondent know about the obligation and fail to pay it willfully? If so, why? Show me that you had an inability to pay, dad. The consequences for willful failure to pay, as you know from other litigation contexts, if you're a litigation lawyer, are severe. You're in contempt of court. So the court can order incarceration, and this is the exception to the right to counsel that I mentioned earlier. In these cases, the respondent has a right to an assigned attorney from the court system. And just to be clear, in case this is an issue of confusion, we want to observe these cases. These are not cases where I said the state is representing a party because it's welfare. These are cases where dad's getting an assigned attorney from the state system, but we want to observe these cases. And so the court, because of the incarceration possibility, which in New York State is fairly rare, some other states have in my view, unfortunate percentage of their incarcerated population are child support debtors. So it's fairly rare in New York that there is an order of incarceration. But sometimes it is the only penalty that the court views as effective against someone who has been given opportunity to pay and given opportunity to get a job to pay and has failed. So what you may see there is the support magistrate who doesn't have the power to say, go to jail, refers it to a family court judge, an elected family court judge, for review, appointed family court judge for review of an order of incarceration. You might also see something, another buzzword to listen for, purge amount. This is an amount of money that the court in its discretion can set and say, if you don't come back in 6 weeks at the next court appearance with $3,000, I'm going to order incarceration. I'm going to recommend incarceration. Magically, many times, $3,000 appear. Again, we can discuss the fairness of this system, but the flip side of this is that the children have been hungry for X number of years when the order has not been paid. So if the goal is to get money to children, this purge amount can often be effective. There's also something called a money judgment. And here again, we're in box 15, enforcement. I'm telling you some words you're going to hear here. Money judgment is an order from the court for the petitioner custodial parent, which says the arrears, the unpaid amount, the $15,001 that has not been paid is now reduced to judgment so that mom becomes a creditor of debtor dad. Meaning, if dad goes to get a car loan, if dad goes to buy property, that can be held up. And if dad is going to pay off any debt, she's a creditor. So for any bankruptcy lawyers, she has priority because she has that money judgment. And something that is very serious is that money judgment accrues 9% statutory interest. So if you've got $15,000 on a money judgment, 9% interest is steep. So you may hear the court say, I'm going to issue a money judgment. Something that came up in some cases is this warrant review. That is a term of the enforcement world. You hear warrant, you know you're in the enforcement world. You know you're in case type enforcement violation. And what that means is that respondent didn't show. And there's a warrant for his arrest. So that if he shows, the courts are going to look for him, and if he shows up and is not pay the child support or some portion of it, he's going to be arrested. Again, a lot of complicated issues with immigration here, very complicated. But that is the enforcement world. Okay. I'm going to show you a calendar. So, you also, I believe, have, I know we have just a couple of minutes, you also, I believe, have, and by the way, at the end of this, I'm going to want to see you, and I'm going to quickly give you assignments with some flexibility for your own schedules, but I want to kind of get you off and going. This is a court calendar. I believe you have in a handout some sample calendars, and this is another example. I'm going to show you how to locate the calendar so that you can decide when you want to go to court. Every day of the week, the courts are hearing child support cases. The date is on the left there. The location of the court is at the top. The FCSM, the Family Court Support Magistrate, in this instance is Harold E. Barr. The part is the courtroom. Of course, to become more complicated than necessary, instead of calling it room 22A, the courts call it 22A. There's often there is in the court lobby a list, court magistrate or judge and courtroom. And it might be listed by part, which is, again, unnecessarily confusing.
Can I just say something? You go in the court, if you don't know where you're going, you can ask.
Yes.
Okay? Just so you know, don't feel like you go, you ask, and it's security, you're going through security, you ask, which is the court. Maybe you have to knock on the door a little, you're allowed in, they're open courts, but there'll be a little process, and everybody knows you're coming, but just, you can ask.
So when you get through the security line, and keep in mind the security line can be long, you don't need to show up at 9 o'clock. But generally the calendar is working like this. They're open around 9 and 2:15. Morning is a much better time to observe. Again, I'm going to empower you to choose when you do this, and we'll talk about some guidance I'll give you. Morning is a much better time to do it. There's much more on the calendar in the morning. You can stay for the afternoon. You can go have lunch and stay for the afternoon if you want. A lot of times the trials are in the afternoon, and they'll be scheduled for much longer periods of time, which is great for you to observe, but it's less data heavy for us because you might only see one case in the afternoon, whereas you're going to see a bunch in the morning. So it's better for us if you observe in the morning. So you see the times, and you see the file number, which each case is unique, except for you may see multiple file numbers for the same family. If I've got an enforcement case against a non-paying respondent and he has a modification case against me because he's saying the reason I can't pay is because it's too high, those cases are going to have one file number but multiple docket numbers. See the docket number? F is support. I don't know why. F is support. I said before P is paternity. And then there's a unique number. At the end of that number, you see the calendar year. In my example on the screen, it's 17. And then F, that's the serial filings. That means that in 2017, there was filing A, B, C, D, E, and now F. So if you see that your calendar has a bunch of letters at the end of the docket numbers, you're probably in modification enforcement territory. Once upon a time in this training, I said to everybody, and I was wrong, that you can use your court calendar, you can rely on your court calendar as a guide to what you're going to be seeing in court. The reason I was wrong is that in most of the courtrooms, the magistrate is not, unfortunately for our project, going to say, okay, file number 1234, docket F 12317A. Wouldn't that be great if they always did that, because you would know a bunch of stuff. You would know what is the purpose, which we call the appearance type. Are you there on our screen for a compliance conference? Are you there for trial? Are you there for post-dispositional review? And it would make your work easy because you just check the box of what's being presented to you. In many courtrooms, they don't do that. I've had some super clever volunteers who have said to the courtroom deputy, the person who sticks their head out of the opaque door for part 22A and says, anyone here to check in for 22A? Harold Barr, anyone here? I've had a lot of clever volunteers who've said to them, I'm here with Her Justice Court Watching. Can you tell me what number, because the courts will frequently sequentially order these or non-sequentially order these, 1, 2, 3, 8, 7, 5, 4. Can you tell me what number is what on the calendar? Because you're going to have this printout, and it's going to be what's on for that morning. So sometimes the deputy is nice, and will say to you, okay, take a second and say, that's number 1, that's number 5, so that when the magistrate, for whatever reason, says, number 5 on the list, you know what number 5 is. Okay? Again, you don't have to have perfect knowledge to do this, because you're teaching from me, you're reading the guide, and you're observing can provide you what you need to tell us. If you can get a leg up, because you can get that calendar to work for you, great. There are even some general things that you will be able to tell. For example, if your calendar for the morning doesn't have any trials, you should not be checking off trial on any observation forms. Okay, look at your purpose. If your calendar has a lot of corporation counsel, that's not a good calendar for you. Those are the people who are from the state representing public assistance in welfare cases. And remember I said earlier, we do not want you to observe those cases. So don't choose a calendar that has a lot of, in the attorney section, corporation counsel. Assigned counsel on the screen here in the fourth box on the right, McAllister, Kevin Lewis, 18B assigned counsel, is fine. That is, in enforcement cases, the right to an assigned attorney that I mentioned for a non-paying, non-custodial parent. That's okay. This case right here, post-dispositional review, that's an enforcement case. You see the docket is 17D. That's a good case to observe. That's an enforcement case, and it happens to be that Harold Barr actually does mostly enforcement cases. But anyway, assigned counsel is fine. But corporation counsel, if you see a bunch of those in a calendar online that you're looking at and choosing to go, that's not a good morning for you. Unfortunately, as I said, they've mixed them up. That's not a good calendar for you. So there are some things. Again, if you see a few fact findings, but mostly return of process, you have a sense of the kinds of cases that you're going to be seeing to inform your observation. And if you can get that courtroom deputy to say to you, This is 1, 5, 8, 7, 9. Great. That would be great for you. That would be a leg up. But don't let it worry you too much, because you don't have to be perfect in what you're telling us. The crux of, and we're getting to this at the very end, but the crux of what we want you to be telling us is this access to justice stuff. It's the 6 through 14 or 13 on the second page of the tool. It's your subjective opinion about whether the magistrate did these things or not. There are some cases, respondent doesn't show up, the court says matter dismissed. That's NA down the line. Nothing happened there. There's no meat for you to tell us anything about, and that's fine. That's a legitimate entry. That's fine. A legitimate submission for us. But in the cases where there are parties there, or there is the court asking questions of the petitioner, did these things happen? Did the parties have enough time to explain their issues? Did the magistrate ask if they had questions? If there was an order in box 11, did the court explain it? A temporary order. Wait for this, ma'am. The court's going to give you a temporary order. Sir, it's going to be paid through SCU. You're going to come back in 6 weeks. I want you to bring proof of your financial to see if we should adjust that. Did the magistrate say that? Or did the magistrate say $50 a week, temporary order? And no one had any idea. Number 12, if there was a final order, that's for final orders only. Did the court say, if you have any objections to this, you can file objections with the court in 35 days of when you receive the order in the mail? Objections are grounds, reasons that you think I got it wrong. Did the court say that, or did the court not say that? 13, would they have benefited from attorneys? Maybe not. Maybe it was straightforward, but maybe people looked unbelievably confused. A lot of people in the courts are non-English, the English is not their first language. On the first page, we ask you to tell us in boxes 4 and 5, was an interpreter provided when requested? Or when it became very clear that someone didn't understand what was going on. I've seen so much rich feedback in box 14. What else do you want to tell us? That is so valuable to us. The observations are wonderful. There are things like, this was way over everyone's head. I have no idea how anyone would do this. Or, boy, this magistrate did a great job explaining to the parties. Took the time to walk through this, walk through that. There's wonderful stuff that people are telling us in box 14, so don't be shy. The way that this works is when you're going to bring these in hard copy to the court. Why? Because the courts have spotty or non-existent Wi-Fi. So we're going to go analog here. And so you're going to bring a bunch of these 2-pagers, and you're going to fill them out for each case. Do not be afraid to take a break. If your calendar shows that there are 10 or 12 cases on in the morning, sit an appearance out. Take a minute. If there was a complicated one that you want to report back on, take some notes while they're doing the next one. That's fine. We don't have a minimum that you need to get to. If you observe 5 cases and you do it meaningfully, great. If you can do 8, great. It's fine. So sit some out. Sometimes people do like to go with a buddy. If you want to do that, great. I mean, we really want you to, as much as I want this experience to be valuable for you, I'm looking for data. So that's fine too, but I've done that with people where Denise observes one, I observe the next while she's making notes. And we're flip-flopping. And it's nice because you can say, do you have any idea what was going on?
Well, I kept asking the person I was with, what case is this?
Yeah, right.
Right. And she somehow figured it out. Well, I was just so busy thinking, God, this is the worst interpreter I've ever seen in my life.
Right.
So, it's nice to go with
somebody. It is nice to go with a buddy, and that's absolutely fine. And frankly, some people find this so interesting they do it twice. So you go with a buddy the first time, and then you go again because the court's near your house, and you're going to go for an hour and a half, whatever it is. But the way that it will happen is after you have your hard copy pages of observations, there's a link at the top, and I'm going to email you all of this as well. I'm going to email you this link too, so you've got it, to this so you can print out copies. There is a link at the top. And it is for a Google form where you should submit these answers. It does not take long if you've got 8 of these from your morning of observation to go into Google Forms and do 8 quick entries. It doesn't take long, but that's what we ask you to do. P.S. While you're doing that, if you are confused about something you saw, email me, call me. I'll make sure you have my info. I'm happy to get your take. I was in court this morning and some crazy thing happened, and I have no idea what context it was, what case type, what posture. Email me. It's actually better that way, so that I'm not going back later and trying to sort of figure out what happened, as much as I trust your stuff. And again, the key of this is in 6 through 14, your subjective observations. Do you want to say something? You just scribbled a note, Denise.
Oh, I just wanted to say something about these observations that are subjective but can potentially also be very objective, because if they say nothing, then clearly it's not just a subjective opinion, they didn't say it. What I've learned about this, and this is a big part of what Modern Courts does, because we don't necessarily always do the data piece, which is essential also, because when you're speaking to the court, you have the data, you have the evidence, right? And that's so important, is that these questions are perceived as sometimes best practices of what judges should do. Procedural justice is what people call these. But the bottom line, what I've read and what I've learned about these kinds of questions is that when these things are done, not only do people understand, the litigants understand what's happening, but there's more buy-in on their part to follow the rules of the court because they feel they're being heard. So it's not just about was the judge clear, were they engaged in their own process so that they know that this is what's happening. So they're really important, and it's really interesting how some judges, or magistrates, they really do this, and some don't. And when you see the ones that don't, you think, oh my God, they're so rushed, how can they possibly do this stuff? Deference to the court, deference to the judge, but then you have your discernment. So these are, for me, often very important. And the data, which sounds really complicated, and I kind of made fun that I didn't know what was going on, but that's just because I can space out sometimes. You'll know what's going on because you'll be focused, right? So you'll be able to do the data. It will come to you very rapidly. Yeah. This will come to you rapidly. And some judges may be helpful. And I just, the one note I had here is, sometimes there's going to be a lawyer for a child brought into a case. Like suddenly there's this thing going on, and what I saw was this case where the mother was saying the father had a car, and who saw the car? The child saw the car. The mother didn't see the car. Boom, the judge goes, bring in a lawyer for the child. So those are appointed by the court, and often they're in the court area. And suddenly there's this law. I'm like, geez, what is this? This is going to complicate everything. But you'll sometimes see that. And the other thing with interpreters, they sit in between the person sometimes or on the side. And I really was thrown when the interpreter was there because it's this simultaneous thing that's going on. I'm not going to judge it. But I did do some research on simultaneous translation, and it is not necessarily the right way to do it, but that's like far away from what this process is. But if you're getting confused when this is going on, you can comment on it, because that's so fixable. So there'll be, times you're like, whoa, what, so those are my two things. Suddenly something's thrown in the middle of the case that's interesting and also confusing. But it may be helpful to the judge, especially when they put in that lawyer for the children. That's what you told me on that case. I was like, why are they? And Rachel said, it helps the judge. There's a lawyer in the case now, whatever that lawyer may be. So, and then I just have one more comment. I know we're over. Sometimes you'll see retained attorneys in there. Yeah. And, it's like, whoa. That's another one of those, like, wow, are they really helping this case? There's that element also sometimes, too. So it's really this little microcosm of what goes on for poor people and what goes on in these cases and what goes on in family court. And economics is the driver. So as confusing as this sounds, once you're there, you'll see the rhythm of it and you'll get it. So.
Okay. Does anyone have questions? If not, I would love for you to come up to me so that I can tell you where to go and when with flexibility for your schedules. I'm trying to do this in a way that works for you and works for us, sort of on the capacity resource end. So that would be great.